All right, folks. Well, we are just getting up to the numbers of registrants. However, it's 3 minutes after, so I'm gonna kick us off. Thank you for joining us for your lunch hour. My name is Austin Davis. I'm the Director of Government Affairs for the Lake Champlain Chamber, and I appreciate you all joining for this webinar about some changes in employment law that came out of this last legislative session. Some of you might have watched these changes as they were being debated, and I think there was a general air of concern among most employers and many who practice in this area of law during the session. Despite this, the legislation did pass and was signed into law on June 20th or 28th rather, only to go into effect on July 1st, very short turnaround time. And with that, I know many folks are scrambling to accommodate Act 80 and to change their training policies, their handbooks, and everything else that goes along with that. So thankfully, we have three fantastic attorneys who were able to join us for this. We were going to have four. Unfortunately, Karen Stackwell had to be called away on an urgent matter. However, really appreciative of her being willing to participate. So I'll just take a second to introduce our panel for today, and then we've got some pre-organized kind of components of this that we'd like to walk through, and then we'll have plenty of time for questions. You can put questions anytime in the chat. Please keep yourself on mute during this, and we'll get underway. So I'll start with Stephen Ellis and just let him introduce himself really quick.
Sure. Thanks, Austin. I'm Steve Ellis. I practice with Paul Frank and Collins, downtown Burlington. And I've been practicing labor and employment law for, I think, 37 years now. And I'm also a litigator. So I have that perspective on this as well.
Thanks, Steve. And then Heather Ross.
Good morning, everyone. My name is Heather Ross, and I practice with the law firm of Sheehey, Furlong, and Behm in Burlington. I wasn't going to say how long I practiced because it makes me feel old, but Steve, you're longer than I have, so I'll go ahead and say 28 years. I've been doing labor and employment law. I am also a litigator, and we look forward to hearing your questions this morning.
And finally, Ben Travers.
Thanks, Austin. Ben Travers. I've been practicing labor and employment law for 12 years, and it's great to be with you all here. Thank you for inviting me. It's also great to be a member of the Chamber Board and to be able to participate with the Chamber in this way as well. I believe, Austin, when I first agreed to doing this, I was still with the Labor and Employment Group at Downs Racklin Martin. Since that time, I've now moved to the General Counsel's office for the UVM Health Network, where I specialize in labor and employment for them, but thrilled to still take part in this conversation and bring my experience from DRM as well as in the current role to this discussion.
Well, thank you. And we'll look forward to Ben kind of talking to us about how you can implement this in your own organization. And well, thank you all. So I think we'll just jump right into this, and Steve has some slides to kind of give you a preliminary introduction to the past standard and how the changes came to be, or what these changes came to be, and some of the perils of navigating them. So Steve, you ready to share your screen?
Yeah. You got it?
You can see it. Just go into, there we go.
Okay. All right, I'm going to just focus on the major pieces of this legislation. I'm referring to it here as S.103. That's the form in which it got marked up. It's was passed as Act 80. We will make these slides available after the program today. There is a link here that takes you to the markup of the legislation that shows the changes that were made to the existing statute. These are amendments to Vermont's Fair Employment Practices Act, and they really are quite monumental. The primary, and again, we're just going to try to focus on the big points here, and we don't really have time to get into a lot of the nuance here. But to begin with, the amendments equate harassment and discrimination. They treat them as the same thing, which is has some very interesting implications. I think we've all understood for many years that harassment is a form of discrimination, but until these amendments to the Fair Employment Practices Act, harassment has been treated differently than other forms of discrimination. The amendments basically treat them as effectively the same thing now. The amendments also expand the pay equity provisions in the statute to all protected classes. Again, this is, I think, kind of a codification of where the common law was already going anyway. The law codifies the don't darken my door rule for all FEPA settlements, and we'll look at that a little bit more closely in a minute. This has been a part of the Fair Employment Practices Act with respect to settlements of sexual harassment claims for a number of years, I think 2018 maybe, but it's now the law with respect to all settlements of FEPA claims. When I say FEPA, for those of you, I think that everybody knows what I'm talking about. It's the Fair Employment Practices Act, FEPA. The big change here is the amendments eliminate the severe or pervasive standard for hostile work environment harassment claims, and adopt really the most expansive definition of harassment that can be gleaned from all of the case law dealing with this issue. So first, it equates harassment and discrimination. The statute says it shall be an unlawful employment practice except where a bona fide occupational qualification requires. Then it categorizes the various protected classes. And it says for any employer, employment agency, or labor organization to harass or discriminate against any individual on the basis of those protected categories. Again, this basically codifies the law. I think we all understood that if you harass somebody because of a protected attribute, a legally protected attribute, you have violated the statute. But until now, there have been some standards around that which have been effectively dissolved. The statute expands the pay equity provisions of FEPA to all of the protected categories. Again, I think this is effectively a codification of where the law already was. The don't darken my door provision, this was really quite controversial in the legislature. I testified for several years running to a number of committees, and lawyers from the plaintiff side of the bar were basically on the same side as lawyers from the defense side of the bar on this issue. Basically, what the statute now says is that you can't, any agreement to settle a FEPA claim can't have any provision that restricts the employee from seeking employment with the same employer in the future. That has been a part of the statute, as I said, for sexual harassment claims for a number of years. It now applies to all FEPA settlements. And the implications of that, I think, were, in my opinion, not really well understood by the legislators. As the plaintiff side lawyers who testified along with me and others pointed out, the ability to agree not to seek employment with the same employer is oftentimes a very valuable bargaining chip for the employee. And without having the ability to bargain for that and to agree to that, it becomes very difficult for a number of reasons to settle some of these claims. It becomes difficult from the employer's perspective to want to pay much, if anything, to settle a claim with somebody that you can't restrict from reapplying for employment because you're going to be faced with another retaliation claim or discrimination claim tomorrow after you've settled this claim today. So we can talk about that more later. But here's the biggie. If you look over the history of how the law developed in this area, Title VII prohibited discrimination starting back in the 60s. When I started practicing law in the 80s, it was still kind of a novel concept that harassment can be a form of discrimination. But the parameters around that were, discrimination is discrimination in the terms and conditions of employment. So you discriminate against somebody in hiring, in promotion, in termination, disciplinary decisions that materially affect the individual's employment. So for harassment to constitute discrimination, the assumption was, well, it also has to have a material effect on the terms and conditions of employment in order for it to be actionable. And so how are we going to define that? And the law for years used this severe or pervasive standard that you can have harassment, but for it to be actionable as discrimination, it has to be either severe or pervasive. Doesn't have to be both, but it has to be one or the other. As a result of this change to Vermont's Fair Employment Practices Act, in Vermont, it doesn't have to be either anymore. It doesn't have to be severe or pervasive. The statute provides what I think was intended to put some guardrails around this, but I think in practice, it's essentially unworkable. What it says is behavior that a reasonable employee with the same protected characteristic would consider to be a petty slight or trivial inconvenience shall not constitute unlawful harassment or discrimination pursuant to this section. What it doesn't say is who has the burden of proof on this. Does the plaintiff have to prove that a reasonable employee with the same protected characteristics would not consider this to be a petty slight, or does the employer have to prove this as an affirmative defense? And what is meant by a reasonable employee with the same protected characteristic? If the protected characteristic, for example, is gender identity, do you have to have somebody with the same gender identity? And what does it mean to be a reasonable employee, and who makes that decision? I guess ultimately a jury is going to decide all of this. But again, this is what I think is intended to be perhaps a defense, or perhaps some kind of a way of putting some kind of standards on the claim. But in my view, it's going to be very difficult to implement this. And again, the amendments codify really the most expansive definitions of harassment that can be drawn out of the case law. It can be harassment regardless of whether the complaining individual is being harassed, whether the complaining employee acquiesced, it can be harassment regardless of whether it's also experienced by others outside of the protected class. In other words, I think this kind of gets rid of the boss is just a indiscriminate harasser. He harasses everybody. Doesn't matter if you're a member of a protected class and you're getting harassed, you can still claim that it's because you're a member of that protected group. So again, it's a very expansive definition of the concept of harassment. You know what? There used to be a case law around these employment claims that accepted kind of as a given the principle, and this language appears in a number of decisions, that the employment laws are not intended to be a general civility code for the workplace. I think it's pretty fair to say that with these amendments to Vermont's FIPA, it really has become effectively a general civility code for the workplace. We're being required now as employers, HR managers, attorneys, we're being required not simply as a matter of good human relations or workplace efficiency and harmony. It's now a legal obligation to make sure that employees aren't experiencing any kind of harassment, regardless of whether it's severe or pervasive or experienced by anybody else. So how are we going to deal with this? Heather and Ben hopefully will help us think about that. It's certainly going to create new headaches for HR. I know my partner, Karen Stackpole, has always said this is an issue that really needs to be addressed through better training and education and not through law and litigation. It's going to be litigated now. These claims can be brought with the Attorney General's Office Civil Rights Division. They're going to come in now and try and figure out whether somebody has been harassed in violation of the Fair Employment Practices Act with effectively no standards for making that determination. Because of the "don't darken my door" provisions, I think it's going to make it very difficult to settle some of these cases. Be happy to talk about that a little bit more later if we have time. I think it's inevitable that there's just going to be more litigation around these issues. I'd be interested to see if anybody disagrees with me about that. So there's a final issue that I wanted to raise too, which is Vermont's Fair Employment Practices Act has been construed to impose individual liability on perpetrators of harassment. Are you now going to have, if they're supervisors, are you now going to have supervisors being personally, individually liable for conduct that is not severe or pervasive, just that somebody has been offended by it? This is absolutely an area where supervisors and managers are going to need to be educated. So I think that's the end of my remarks. And again, I'll be interested to participate in discussion around all of these issues.
Thank you, Steve. So I think, that sets us up really nicely to move to a quick conversation with Ben about like how you should initially navigate these things. Ideally, it doesn't end up in litigation as you worried there, Steve. But Ben, what do you think?
Yeah. So thanks, Steve, for the great presentation. And yeah, let's talk a little bit now about sort of implementations, how it's going to work at different employers. Obviously, the first thing that comes to mind is I expect that most of you have, or at least should have, written policies on sexual harassment, on discrimination. And I don't want to steal Heather's thunder, but I know that Heather in a moment is going to speak to changing your policies. But that first and foremost is what folks should be thinking about is looking at your handbook, looking at your policies, to the extent, of course, you have policies that define sexual harassment as severe or pervasive conduct. That's going to have to change, and I'll let Heather speak to that more specifically. After Heather speaks to the policy changes, I'll also then chime in some more along with Heather about new trainings for employees. So trainings for your managers, trainings for your HR professionals, and then of course trainings for individual employees themselves. So Those are the first two items that, from my perspective, come to mind, and we'll take some time in a moment to speak more to, along with Heather, again, modifying your policies and modifying your trainings. Before turning to Heather on policies, though, there were three items that I wanted to raise and discuss that are responsive to some of the issues that Steve just brought up there. So I sort of view the changes in S.103 as falling into these two different buckets. One is the extent to which there were changes made to our statutes on pay equity and adding those additional protected classes. And then the other, of course, is the changes that were made to how we define harassment and how we define sexual harassment. I completely agree with Steve that to the extent there were additional protected classes added to our statutes on pay equity, that for the most part, the law was being updated to reflect what we already understood to be the case, right? If you were paying women less than men on account of them being women, if you were paying someone on account of their race less than other people of a different race on account of their race, even without our updating our pay equity statutes, that would be an issue. What both the changes in the pay equity law do, though, and the changes in the harassment law do, is it provides additional avenues for employees, for regulatory authorities, and of course for attorneys representing those employees to bring legal claims and raise issues for their employers. And so the three issues that I want to talk about before turning to policies and trainings are sort of what you all should be thinking about in anticipation of the possibility of expanded, more frequent, increased legal action. So first of all, in terms of the pay equity statute, to the extent those of you have a large enough organization where this makes sense, a reminder that sort of oftentimes a transparent pay equity audit can be a good step for you to ensure that you, in fact, do have pay equity across your organization. Now, sometimes when folks have done that audit, they actually have done the audit by taking into consideration different folks' protected classes. So historically, the pay equity law has largely focused on gender inequity, and in doing pay equity audits, a number of employers have sort of done a self-evaluation of, are they in fact paying men more than women for similar work? You could extend that pay equity audit to additional protected classes. For some of the additional protected classes that are now sort of black letter in the law protected, they are protected classes that are more on the face of the employee, like gender. You have some sense as to the gender makeup of your employees. You have some sense as to the racial makeup of your employees. I think one of the things that's difficult here is that there are some protected classes that are now expressly protected in the law that are not as sort of on the face. You don't know every employee that has a disability. You don't know or ask about the sexual orientation of all of your employees. And so in doing a pay equity audit along those lines, it's more difficult now to look at that through the lens, and the same lens that you would look at in being able to do a pay equity audit based on gender, as many organizations have done in the past. Rule of thumb, though, here is what you should be looking at in doing any pay equity audit is, regardless of folks' gender, regardless of any protected class, are people being paid differently for similar work? Right? You do the pay equity audit, you look at folks who are in a similar position doing similar work. Do you have folks who are flagged in that audit as being paid differently? And then doing a deeper dive into, well, do you have legitimate reasons as to why that may be the case? Do there need to be changes to mitigate any potential legal risks now that there's the potential for increased litigation in terms of pay equity? So happy to answer any questions around that, but that was one issue that I wanted to raise. I also completely agree with Steve, and I think Heather will agree as well, that particularly in terms of the changes that were made to the statutes around harassment and sexual harassment, that there is a significantly increased risk of legal action, either a private lawsuit against an employer, a demand letter from an employee who's reached out and sought legal counsel, someone going to the Equal Employment Opportunity Commission or to the Attorney General's office. And I think employers, to the extent they haven't already, should be taking steps to ensure that they're, again, mitigating against that risk. And certainly one of the ways to do that will be through policies and trainings. But the two things that I wanted to flag right now are, one, if you don't have or don't know if you have employment practices liability insurance, or sometimes directors and officers or D&O insurance, which potentially could extend to your higher level directors and officers in terms of individual liability, if they were sued, like Steve just mentioned, it's worth reaching out to your insurance broker to confirm if you have employment practices liability insurance, EPLI, directors and officers, D&O insurance. And if you don't have it, I would strongly recommend that you get it. That can be a real lifesaver in the event an employee takes legal action against the organization. And the next thing that I wanted to mention, and this is a shameless plug for lawyers, is to the extent you don't have a relationship right now with local employment counsel, I think it's worth your reaching out and establishing a relationship with local employment counsel. I can't speak for Steve and Heather. What I can say is that when I was at DRM, it didn't cost employers any money to reach out and for us to have a conversation initially to try to establish that relationship and see if we would be the ones who are a phone call away in the event things go sideways. So certainly we'll plug my former firm at Downsback and Martin. We'll plug Steve and Heather, very able employment counsel. I see a number of other folks here on the participant list as well, at a number of other very reputable firms in town here in Burlington and elsewhere, and would suggest that it is worth having that relationship and having really qualified expert legal counsel a phone call away in the event things go sideways, because unfortunately I do think it's more likely than it was in the past that things will go sideways under the new law. So looking forward to talking more about policies and about trainings, but Heather, if it makes sense to you, I think I should turn to you now to speak to people amending their policies.
Great. Thank you, Ben. I agree wholeheartedly with what both Steve and Ben have said, that unfortunately the changes to this law are likely to increase litigation on these topics, which does put employers in a difficult position. I will say, in trying to focus on what are the proactive steps that employers can take to address this new law, updating your policies, training of managers and supervisors, as well as educating all employees, and having local employment counsel to whom you can reach out and run scenarios by are three really critical steps to helping to protect your organization. That being said, I would like to take a minute to talk about policies. Now, everyone should have a sexual harassment policy. Vermont law does require employers and organizations to have a sexual harassment policy. So first and foremost, you should have one in place. And if you don't, both because you're required to legally and because it is an important mitigation step, you should put one in place if you don't have one in place already. Vermont law requires very specific things to be included in your sexual harassment policy. These things, according to Vermont law, are the following: that a statement that sexual harassment in the workplace is unlawful, a statement that it is unlawful to retaliate against an employee for filing a complaint of sexual harassment or for cooperating in an investigation of sexual harassment. A description and examples of sexual harassment. A statement of the range of consequences for employees who commit sexual harassment. And if the employer has more than 5 employees, a description of the process for filing internal complaints about sexual harassment and the names, addresses, and telephone numbers of who employees should make those complaints to within the organization. And finally, the complaint process of the appropriate state and federal employment discrimination enforcement agencies and directions about how to contact those agencies. I mention those because it is a good refresher, even without the changes in the law. I do often see sexual harassment policies that miss one of those components. And oftentimes that's how to contact the appropriate state or federal employment discrimination agencies. Let me also say this, it is in general has been my practice, and you know, Ben and Steve can speak to this as well, that because employers may be bound to what they write in their employment policies, that I typically don't advise you writing in policies that go beyond what the law requires. I say that because in doing this for 28 years, I have seen incredibly well-intentioned employers still have difficulty complying with just what the law requires. So binding yourself to do more is not something that you want to be obligating yourself to. Instead, focus on complying with the law and do it right. It's interesting that the legislature, although not surprising, that the legislature did not amend the provision of the statute that has to do with the sexual harassment policy. And that is, the policy requirements are at 21 VSA 495H, and I'm happy to circulate them so that Austin can provide them to others after this webinar. But 495H of the statute only requires a policy on sexual harassment. Now, as you've just heard from Steve and Ben, the Vermont Fair Employment Practices Act has extended the definition to harassment for all other protected classes. However, the training or the policy requirement has not been so extended. So one of the things that employers need to decide is whether they want to broaden their policy to include those other protected classes if they have not already. And one thing that I would say about that is that, you know, the advantage of asking people to come forward with complaints and bring them to HR on any grounds, whether of any protected class or otherwise, is that you can know what's happening in your organization, find out those problems, and resolve them. And the idea is that if you are proactively resolving problems, that in and of itself will mitigate litigation. the flip side of that is what I just alluded to. If you expand your policy and you also to include all protected classes, and you also impose upon yourself a complaint process for those other protected classes, you need to be sure that you're taking those complaints seriously and following through on the process that you impose in your policies. So if you wanted to strictly comply with just the legal requirements as they are currently written for sexual harassment policies, in light of the changes to the definition, how would one do that? Well, there is actually, it required me to look back at 495H very closely, and it does say that one is to give a description of sexual harassment. Sexual harassment is defined in the new law. It has some changes to what the definition was before, but it still begins, as most of you may have who have policies, it still begins saying that sexual harassment is a form of sex discrimination and means unwelcome sexual advances, requests for sexual favors, and other conduct of a sexual nature, and then goes on to discuss the circumstances of when submission to that conduct is problematic or has the purpose or effect of creating a hostile work environment. So in other words, there is a definition of sexual harassment still in the new law. It has some tweaks compared to what it states before. That is different from the definition of harassment generally, which appears in a different section of the statute. And actually, Steve had been talking about that section, that definition section earlier. So again, your policy requires some tweaking for sexual harassment definition because the definition has changed. But, you know, as I read the statute and the fact that the statute with respect to the policy has not changed, I do not think that you are required to, you know, use a broader definition of harassment when you're simply talking about sexual harassment. You may use the sexual harassment definition. I have also recommended that employers add in what has been described today as a attempt by the legislature at restricting or putting some parameters around what the law means and is. And that's the statement that behavior that a reasonable employee with the same protected characteristic would consider to be a petty slight or trivial inconvenience shall not constitute unlawful sexual harassment. We don't know what that means for the reasons that Steve has already described. And so I have recommended to employers just putting that language in exactly as it states, because I don't know how to further distill that down, since we really don't know what a reasonable employee with the same protected characteristic would be at this point. I would also say that, as Ben mentioned, if your policy refers to severe and pervasive conduct, that would be no longer appropriate and should be stricken from your policy. Again, I recommend that what you insert is the definition of sexual harassment that appears at paragraph 13 in the in Act 80. And then I think both Ben and I are going to talk about training, because training is going to be really critical in terms of trying to mitigate liability. The last point that I would make, and then I'll turn it back to Ben so he can talk more to you about training, is simply to come back to the point that Ben made about running things by your local employment lawyer, whether that's, you know, our firm at Sheehey or Steve's firm at Paul Frank, or any of these, you know, and any of the other law firms you might work with. The reason I say that is, and I'm sure we can all three attest, that, you know, and an ounce of prevention is worth a pound of cure. Stated differently, the legal bills that you incur to get some legal advice on how to deal with these complicated employee scenarios is, you know, negligible compared to the cost of a lawsuit. And so, you know, I know it's expensive to contact attorneys, to contact a lawyer, but again, I can't emphasize enough that it really is negligible to a lawsuit, the cost of a lawsuit. So with that, I'm going to turn it back to Ben to have him start talking a little bit more about training management and how that can help mitigate your risk.
Thanks, Heather. I also see a couple questions in the chat here. Linda, I will get to your question now, and talking a little bit about training for management. We'll then turn it back to Heather regarding training of employees, and then we'll open it up more generally for Q&A to the extent we have time. Steve, I see Sophie's asked a good question here in the context of public employees with First Amendment rights, and the intersection between these new laws and folks claiming that they're exercise freedom of speech in the public employment context. So maybe Steve, if you want to start noodling over that question, we could turn back to you after Heather and I talk briefly now about trainings. So, you know, first of all, in talking about trainings for management, let me say that I completely agree with Heather that in terms of your written policy, the written policy should align with what the law is. And to the extent you set a higher standard, which I think most employers do and historically have set a higher standard than what the law requires, you know, one of the risks of you putting that higher standard into your handbook is that you could have employees turning around and claiming that that is some sort of contractual commitment, and it gives rise to a potential other legal claim along those lines. That said, again, I do think that while our written policies have been one thing, and you know, have oftentimes historically been limited to the actual definition of sexual harassment, I think most employers, myself included, would agree that the standard that we put in place for what is acceptable or unacceptable workplace conduct has always been lower than the standard that rises to the level of something that someone can actually bring a lawsuit for. So, you know, to a certain extent, I do think that the changes in the law are meant to align with what we already consider to be inappropriate workplace conduct. The concern, of course, is that the change in the law could rise to additional litigation. That all said, in trainings with management, I think it's nonetheless important to reset the bar, right? And that's what the law has done here. You know, the bar is in terms of sexual harassment, in terms of harassment. Now, it's no longer severe and pervasive conduct. It's no longer the case that it must substantially interfere with someone's work. the bar with what we can or should tolerate in terms of what's inappropriate workplace conduct is lower. And we need to make sure that all of our managers, HR professionals, and those who are managing their employees understand that the legal bar has been changed. Second is that this is a great opportunity to reaffirm the rules. It's now black letter in the statute. Steve was talking to it previously, that harassment can take place both when employees are at work as well as off the clock, outside of work. I mean, I will tell you that in my practice with a number of clients, a number of times I would still see situations where something would happen between two employees off the clock, and folks were of the mindset that because it didn't happen within the office, that didn't rise to the level of harassment or sexual harassment. That has never been the case, and now it's definitely not the case, because the law very clearly says that off the clock conduct will apply here. The law very clearly now says that harassment can be present regardless of whether an employee has acquiesced to it. I think certainly the standard's still there that if there was a consensual relationship and the conduct was welcomed in the sexual harassment conduct, I think that still presents a defense. But the law is drawing a distinction now between, I think, welcome conduct and conduct to which an employee has acquiesced to. The law makes it very clear around that as to what the rules are there. As Steve has mentioned, it makes no difference if the conduct has also been experienced or not by other employees in the same protected class. It also makes no difference whether, regardless of the conduct, the employee was able to continue carrying on their job duties. And it will be important for the trainings that you're doing with managers, again, to reaffirm all these rules, reset the bar as to the new legal definition, and reaffirm what the rules are surrounding that. It can be on the clock, off the clock conduct. It doesn't matter if the employee was able to continue doing their job. It doesn't matter if they ultimately acquiesce to the conduct. This can all rise to the level of harassment and sexual harassment. The other piece here, and again, I don't think that this is the same advice we would have given you 6 months ago as we'll give to you now. But it's important that, and this is particularly for HR professionals, but also for managers, that they really be active participants in seeking out and addressing this conduct. Managers, HR professionals can't sit back and wait for this conduct to come to them. To the extent you see it happening, to the extent you become aware of it, to the extent another employee who it didn't happen to but witnessed something comes forward to a manager, it's important that managers and HR professionals be really active participants in addressing that conduct. So to Linda's question before of how do we train staff to look for harassment when the first instance becomes the claim itself, yes, you can only be active in a proactive way about the items that you're aware of. But of course, if the first time you become aware of it is when the claim itself comes forward to you all, then it becomes important to ensure that your managers and those folks who are tasked with conducting investigations are really trained on how to conduct a proper investigation. Not only is that the right thing to do for your employees and the employees who have been the victims of harassment or sexual harassment, but also to the extent we've been talking about how to mitigate against risk in the event of increased litigation. A good investigation, a well-documented investigation, is going to be incredibly vital to building your all's defense against a potential legal claim. There are professionals like Heather and others who, both lawyers and non-lawyers, who are able to assist with those types of investigations. But certainly many of these investigations are those that your own HR staff can do. We could do an entire hour-long session, if not more, on investigations, but really high level here. It's important to leave no stone unturned. It's important to ensure that from those employees who are complaining, that you get absolutely all the information from them that they have to share, that to the extent they've identified any witnesses, that you're following up with every witnesses, that you're providing the employee or employees who have been complained about an opportunity to be heard and an opportunity to provide their side of the story. And then throughout all of this, to ensure that you're documenting the investigation. How did it come in? What steps did you take? What did you learn for other employees? Because in the event it turns into a legal claim, your investigation documents and what you've done here is going to be Exhibit A in the employer's defense as to did they do everything they could within their power to avoid this from happening. Really high-level discussion, trying to get through there in a few minutes. But Heather, I know you have potentially some other things to add as to trainings for employees, which I'm sure there will be some overlap with some of the items that we talk about in trainings for managers, but also perhaps some additional pointers for employees themselves.
Thanks, Ben. Yes, so I will try to make this quick by just hitting on a few points so that we can leave at least a few minutes for questions. I will echo what Ben said, that Steve, Ben and I could probably do an hour-long presentation on how to conduct investigations within your organization when these claims come up. And, Austin, maybe that's something for another topic, as it will continue to be more and more important to make sure you're mitigating risk. But training's encouraged, not required by Vermont law, training of managers and supervisors. As we all are saying, it's more important than ever to do the training, to document that you've done annual training. And when it comes to staff, training of staff, for me, does look different from managers, training of managers and supervisors, which is a very fulsome training, because they do need to know how to respond to these complaints, and they need to have an understanding of what the law is requiring. With respect to non-supervisory employees, I think that the important things for them to know is that, one, that your company has a policy, that it takes these matters seriously, that it will not retaliate against anyone for bringing forward a complaint, that, and you should review your policy, not just say that you have a policy, but actually pass out and review it with employees. And I think that I will say that I go through the definitions that are in the policy with employees, and generally what that means, breaking down the legalistic terms. But I suggest that organizations tell employees, but just if you have a problem, come forward. Please don't get hung up on trying to figure out whether you think this is unlawful harassment as a matter of law. That can be a very complicated issue. If you have a concern based on any protected characteristic or any other type of concern, please let us know so we can engage with you and help resolve that concern. So those are the highlights of what I suggest a company does in training all its employees about its sexual harassment policy. I'm going to turn it back to Austin just to see if we can get in a couple of questions.
Yeah, I understand we're coming up on the end of our time, and I want to be respectful of everyone. I think we can just kind of drop off as we will, and this is recorded. I'll provide a link to the recording to folks as needed. But we did have a couple questions in the chat, and one was about the conflict with another employee's freedom of speech. And Stephen, I don't know if you want to kind of just give a really quick. I know that we could probably we could do a whole webinar on that. Is there anything you can just kind of really quick talk about on that?
Well, I think Sophie certainly understands this, as did Ben in his response to that question. But I think that the first thing that needs to be recognized is that this only is a concern for public employers, because the First Amendment really doesn't have any any role in private employment, your First Amendment rights can only be infringed by the government. So if you work for a public employer, you have potentially First Amendment rights that your employer could potentially infringe. There's a whole body of law around when an employee is exercising their First Amendment rights as opposed to simply doing their job. And there's also a whole body of law around when an employer can put reasonable regulations around even public employees' exercise of free speech. So in the private workplace, I think the answer to the question is probably there certainly can be a conflict between people saying I'm just exercising my First Amendment rights and somebody else saying no, you're harassing me. That can be true both in the public and private context. It's only a First Amendment issue if it's in the public context. I think in either context, an employer can put reasonable restrictions around what employees can say. And if what you're saying is creating a hostile work environment for other employees, your employer doesn't need to let you do that. I mean, this comes up in all kinds of contexts, logos and slogans on hats and T-shirts, and Post-it notes on people's computer monitors and screensavers, and it's a vast subject. As you said, it could be a subject of a separate webinar.
And it's a subject that actually the attorneys on this call, including Steve, helped with during this past session, as workplace speech was a topic of discussion in this piece of legislation and in others.
That's right.
Around, especially captive audience. But that is something that the chamber is monitoring and will be likely dealing with in the coming session. So feel free to email me or the chamber, just advocacy@vermont.org if that's something you're interested in. I think maybe just one more question, and we'll just end a little late. But someone just asked, would anyone in the legal panel be willing to share what your updated sexual harassment policy states? I think we could probably go back through this and look at kind of like, I think you laid out a good model, but is there anywhere that folks have kind of published a good model language or anything like that?
The state has one available on the Department of Labor website, right, for a model sexual harassment policy. I don't know if that's been updated yet to comply with the changes, but that's where traditionally you could go to get a policy that is presumptively going to pass legal muster. There's a model policy.
And if anyone finds that policy has not been updated, feel free to email me again at austin@vermont.org, and I can speak with folks at the Department of Labor. Do you have any other questions? Well, while I'm waiting to see if any questions come through, I just want to make a pitch for a couple things. I put in the chat about Advanced Champlain, which is a skills-oriented, skills-focused leadership training that the chamber is offering. And applications are actually early bird applications, as I understand it, are closing tomorrow. And they'll be open for a little bit longer after that. I also want to make a plug for a webinar that will be holding next Friday on paid family and medical leave, and a voluntary program that's in phase 1 of its rollout that's been stood up by the administration. It'll be available for all employers in the state to enroll in this program that's slightly subsidized than a market program due to joining in a risk pool with Vermont state employees. Employers will be able to join in July of next year, and then all employees in the state of Vermont in phase 3 in July of 2025. So if you're interested in more about that, we'll be hosting a webinar on Friday with folks from the governor's office, the Hartford Group, which is the third-party vendor who is administrating this program, and a number of other folks. So mark those on your calendar. If we have any more questions, we can answer them now. I'm not seeing any. Oh, and someone just put in the chat that it looks like the state has not updated their policy. So I can go ahead and reach out on that. Well, hearing no more questions, I just want to thank our panel, Stephen, Heather, Ben, and Karen, who couldn't be here. Well, this is the first time you've seen them really interacting with this policy. They were, their help was immeasurable during the legislative session, as myself and many employers reached out to them and used them as a sounding board as this legislation was going through. Thank you all for joining, and we'll follow up with more details.